This will assist in your next step, whether you are a pro se litigant or you're going to a lawyer. I do recommend very strongly that you seek the services of an attorney. I know that when I began my work more than 2 years ago, I was encouraging many people in their pro se litigation. Things have evolved to the point where the pretender lenders, the non-creditors who are seeking to collect on the note or foreclose on the mortgage, have become more sophisticated in their responses, both procedurally and substantively. I think that most people who would seek to be pro se litigants are going to find that they're in over their heads without the assistance of an attorney. So I strongly recommend that you do go to an attorney. And this attorney will seek to use the expert declaration and all the other information that you've gathered in order to, if necessary, get a temporary restraining order or otherwise stop any action by the servicer or pretender lender or whoever the participant in the securitization chain is that is seeking to collect or enforce or foreclose in your situation. Now remember, this information applies not only to people who are in foreclosure, but for people who are current in their payments and are considering what to do about the fact that the value of the property has gone down so substantially that they may never see the light of day again. In other words, those underwater mortgages where the amount owed on the note vastly exceeds the true value of the property. And frankly, if you really look at the true value of the property on sale in terms of what the proceeds would be after a real estate broker takes their fee and after all the other expenses, you'll find that the number that is estimated out there about people underwater is probably 2 to 3 times what the published estimates are. I would say there's probably around 12 or 13 million homes in the United States alone where people are either at the break-even point or underwater. And according to the most recent studies, when people are in a status where the value of their home is less than 75% of what they owe, they are looking seriously at the possibility of just walking from the home. So let me talk a little bit about that option, which is clearly gaining momentum in the marketplace. For those people who have a $300,000 mortgage and the house is only worth $160,000 and they've perhaps gone through the what I call bogus modification process at most servicers, which results in nothing happening, or a modification that is temporary and results in foreclosure anyway 6 months later, they are looking at the prospect of simply renting a house for perhaps half or less than the monthly payment being demanded of them for the ownership of the house that they're in. And considering the number of foreclosures and the number of people who have taken a hit on their FICO scores as a result of this recession, it is probably true that while there is a hit on the FICO score, it may not be as important as it once was to see a foreclosure. Whether or not you decide to walk or to fight is, of course, your decision. I certainly would like to see you stay in your home and fight it out, because I think that's what's best for our society in general. And I think it's what's best probably for you if you didn't have to move. But it's a personal decision and a legal decision, and you should consult with the appropriate people before you make it. So, assuming that you decide to stay in the house and to fight to stay in the house, if necessary, then you're going to seek a temporary restraining order. You might file a bankruptcy action, which results in an automatic stay and prevents them from going forward until they lift that stay. And it's in the motion to lift stay, just like the motion for temporary restraining order, that the issues are joined as to whether or not these people have the legal standing or the right to be proceeding against you at all. And on the blog, you'll see that there have been numerous decisions, including one recent one from Vermont, where the judge brought it up himself without there being a motion from the homeowner, and basically said that the party, in that case, MERS, Mortgage Electronic Registration Systems, didn't have the right to be bringing any kind of foreclosure action, and he vacated the foreclosure that he had previously granted and said that if the proper plaintiff ever wants to step forward, that they can do so, but that MERS was neither the beneficiary nor the creditor, and therefore had no right to be in court. And that's true for servicers and all of these other people who are in the securitization chain. Your creditor, in all probability, is an investor, which is a pension fund or a sovereign wealth fund that purchased certificates of asset-backed securities. And in that purchase, they received a promise to pay and a conveyance of a percentage interest in a pool of mortgages that presumably included yours. Now, the question is, are they the creditors, or is it the federal government through the bailouts or through the AIG payments on the insurance to Goldman Sachs and JP Morgan, Chase, etc.? The fact that there are third-party payments which did occur in connection with these mortgages leads to a question of fact. And your objective, and your lawyer's objective, is at the beginning not to get the judge to agree that you're right and the other side's wrong. Your objective is to get the judge to agree that there is a question of fact that needs to be decided by an evidentiary hearing. If there is a credible question of fact as to who the creditor is and how much is owed and whether third-party payments were made, then the judge will, in most cases, allow you to proceed in discovery and allow you to proceed towards an evidentiary hearing. This, in turn, will most likely lead to a settlement, modification, or mediation of your obligation, your transaction, in which you receive a substantial principal reduction on the amount owed under the mortgage and a substantial change in the terms of the mortgage such that you get a low fixed rate for 30 years.